We are here at the Law Professor YouTube channel once again. Don't forget to subscribe to this channel, to like and to share. Today's presentation, we'll be looking at a problem question in the law of contracts. We are going to try to create a structure for answering your questions, your problem questions. So we are using the law of contracts as a test case. So I'll read the question to you and then we'll try to develop a structure for your answer. Now the question is taken from the first semester examination for 2023-2024, and it says law class set 2024 are planning to hold end of session party on the 22nd of July 2024 using Unique Multimedia Theatre UMT as the venue. Set 2024 wrote a request to Mr. Perfect, the newly appointed manager of the UMT, seeking for permission to use the UMT. On the 5th of July 2024, Mr. Perfect replied set 2024, stating that, quote, in my opinion, the UMT is the best venue for such events and it has the carrying capacity of 2,000 students, end of quote. Set 2024 thereafter signed the contract for the hire of the UMT for the class party scheduled for 22nd of July 2024. However, on the 19th of July 2024, the management of UMT carried out maintenance audit, which revealed that the maximum seating capacity of UMT is 1,000 students. Meanwhile, the ticket for the class party was sold to 2,000 students on the 22nd of July and 2024. Only 1,000 students were admitted in the UMT, while the remaining 1,000 students were denied access into the venue. When the party was about to start, it was discovered that the air conditioners were not functioning and only 2 fans were working. The situation of the UMT could not be corrected. The hall became inhabitable and about 750 students left the venue and demanded for the refund of the money they paid for required for the refund of the money paid for the tickets. Said 2024 intend to sue UMT management and claim damages for misrepresentation, identify the legal issues and advise the parties using appropriate legal authorities. So your question is to identify the legal issues and advise the parties using appropriate legal authorities. So we are going to just look at the framework of what your answer should compose of. Now it says that you should identify the legal issues. As a student of the law of contract, how many legal issues can you find in this question? Your legal issues are developed when you are reading for your exams, when you are studying, when you are meditating, because it is the law that is that gingers questions, that gingers replies, that as a lawyer, what are the things that are wrong with this? So this is supposed to be a contract. Has the contract been fulfilled? Has it been met in all the way that the law requires that you meet a contract? So you get the issues by first having the knowledge base of law. Then in the exam, you look at the facts, what has been done with respect to the contracts and what has not been done, and test that against your knowledge. So the set 2024, in trying to enter into a contract with UMT, dealt with who? Mr. Perfect. Who is Mr. Perfect in this contract? Is supposed to be the manager of the hall. Okay, so when he said, in my opinion, this is the best venue and has capacity for 2,000 students. So you have to look at whether that is really an opinion that should be taken as a part of the contract, or is just something that should be discarded. So, and that's the status of this man is very critical. So do you think that the manager can express this opinion and this opinion can form a term of the contract? And then you ask yourself some other questions. Now look at the date that they asked the question. They asked the question 5th of July, and they signed the contract on the which date now? The day after they signed the contract and hired it based on that opinion. Now the question says on the 19th, because you have to pick the facts out. Okay, they audited it and they found out that you could only seat 1,000 students, 1,000. So from the time they did, so let us even assume in your exams, because they told you he's newly appointed, so perhaps he didn't know when he was giving them that information. But the audit was carried out, and then he therefore realized that he could seat 1,000 students. What did he do with that information? So what am I saying? you need to tease out the facts. When you tease out the facts, look at the dates. Those dates are not just there, they are for a purpose, and they should give you some indication of what the examiner requests of you. So the facts also reveal that they could not take 2,000 students, of course. They could only admit 1,000 students. Then the facts also reveal that apart from the capacity, what else was wrong? Also, there was no air conditioning system, only fans. So nothing was said about air conditioning expressly in the facts that we have been given. But you know that in contracts there are some terms that are implied. So you may want to look at the question of implied terms. Can we imply that into the contract? And if that is impliable, then what is the implication of breach of both the express and the implied terms of this contract? Now the people that entered could not stay, and of course that means they could not even use it for the purpose for which it was meant. So in answering your question, therefore, you pick out the legal issues. Is there an issue with the capacity, with the opinion that you expressed about capacity? Is there an issue with the possibility of changing the information he has given them? Is there an issue with the fact that they could not even, even the 1,000 students could not even use the place? And when you pick out the issues, you now discuss the law. Issues, okay, regarding the opinion, you have picked out the issues. The examiner is going to give you some scores for picking out the issues. If there are 3 issues there are scores for those issues. Then you tell us what is the law. I have always said, even within a problem question, you have opportunity to write an essay. Write an essay about what the law says about misrepresentation, the terms of the contract, implied terms. You have to write an essay. Give the examiner the cases or the statutes, whatever is relevant. You write that essay as the rule, what you call IRAC. So you pick the issues as the examiner has requested of you. You pick the rules, that is the law. State the law copiously. That is the cross, that is the rule, that is the major part of your scores. Then you now apply it and say, oh, you think that this question or this term by the Mr. Perfect is part of the contract and they were right to have relied on it. You have to apply the law in that respect. Then, having said that, it says advise the parties using appropriate legal authorities. So that what you are advising is everything you have said, what you have said. So you can tell them, a lawyer in practice, you don't just tell the client a story and say this is law. You tell them what steps you are going to take as a lawyer to get them their rights, to remedy the situation, to enforce their rights. So you might conclude by saying this person can sue for breach of contract on the grounds of ABC. When you are able to say that, you are giving the advice that they need. And this is a question that is a whole question that carries the entire maths. So whatever time you are allocating for each question, you must use this extensively on the question. Don't forget what I said. I'll just give you the framework, how to analyze your question. You need to now put content with this analysis into the answer by sitting down and writing down what you would ordinarily write in an exam condition. I'll see you at the next presentation when we're taking another problem question on another subject.